Welcome to Copyright Act 1989, Work Made for Hire and the Faculty Exception. The purpose of this video is to provide university faculty members with a clear understanding of copyright law as it relates to the instructional artifacts they create and the research they conduct during their employment with the university. True or false? As a faculty member, I own all rights to the instructional artifacts I create, as well as the rights to any research that I conduct while employed by any learning institution. If you answered false, then you are correct. Let's take a look at why this is true and how it affects artifacts created and research conducted by faculty members. In 1909, a revision to the original Copyright Law Act was made. This revision added the phrase, "work made for hire" to the law. The law deemed that an employer is considered the author of works made for hire. However, the law did not clearly establish what the phrase "works for hire" actually meant. In fact, it was not until nearly 70 years later, in 1976, when the phrase "works made for hire" would be clearly defined. According to Logge et al., the United States Supreme Court defined the phrase "works made for hire" as a work that is prepared by an employee during his or her employment. Notice there is no exception for employees of any type of institution. The second definition provides criteria that the work is specifically ordered or commissioned. Then it goes on to provide examples of works, including instructional materials such as instructional text, tests, and answer sheets. Then it puts the condition of both parties having to expressly agree in writing. Often this agreement between parties comes in the form of a contract where faculty members agree to follow institutional policies and procedures. In essence, it is possible for a faculty member to express agreement upon signing a contract. In 1989, yet another revision was made to the Copyright Law Act. This revision would go on to define the criteria for determining if an individual is an employee and if an institution is an employer. Notice that not anywhere in any of the revisions is an exception made for any employees, including faculty members. What happened to the faculty exception during the revisions? Where did it go? Logge et al. Quoted Leip as responding to the question in the following manner. The 1976 Act did not disturb professors' exception from the work made for hire doctrine. To the extent that such an exception ever existed, it continues to exist. In order for faculty members to have had been overlooked or eliminated would mean that it would had to have existed in the first place, which it never did. So how do faculty members protect works created by them while employed by an employer at an institution that provides space and resources for them to work while paying them and supplying benefits, and who often have some say over the projects or works that are made? First, read the contract, or have a lawyer interpret the terms of the contract for you. Second, know and understand the institution's policies and procedures. Have a lawyer help you interpret the terms of the contract in accordance with the institution's policies and procedures. Third, discuss the policies and procedures prior to employment at the institution. Fourth, get all agreed upon terms in writing prior to beginning employment at the institution. Remember, no faculty exception exists, and the best way to protect yourself is to get it in writing ahead of time. Thank you. This has been Copyright Act 1989, Work Made for Hire and the Faculty Exception.